Hi, Natalie Paskowitz here, owner of Paz Mediation, located in St. Petersburg, Florida. Today on Mediation Minute, I'm going to be discussing non-binding arbitration. Florida Statute 44.103 permits the court to refer any civil case that's pending in circuit or county court to non-binding arbitration with or without the consent of the parties, very similar to how a court-ordered mediation would happen. When this happens, a third-party neutral, the arbitrator, will review the facts and the law, and they will come to a decision and provide that decision to the parties in writing. The decision provided by the arbitrator is usually a pretty good indicator of how a court might rule if the case would have gone to trial. Once the parties receive the written decision by the arbitrator, they may accept the decision, in which case that decision will be referred to the presiding judge, and that judge will enter any orders or judgments necessary pursuant to the terms of the decision. Oftentimes, however, one party may not be happy with the arbitrator's decision. If this is the case, then that party will likely request a trial de novo, which just means that instead of accepting the arbitrator's decision, they would rather go to trial. It's important to note, however, that the rejection of an arbitrator's non-binding decision could result in fees or costs to the party that rejects it. You can read in more detail about that in Florida Statute 44.103 subsection 6, which discusses the potential repercussions for the side that rejects the arbitrator's decision. This actually operates very similar to Florida Statute 768.79 when one party rejects a proposal for settlement or an offer for judgment. In short, if the plaintiff, for example, rejects the arbitrator's award, files for a trial de novo, but obtains a judgment that is at least 25% less than the arbitrator's award, then the court can assess costs and fees against the plaintiff. And of course, on the flip side, it works the same for the defendant. In short, non-binding arbitration has advantages, including a much less costly alternative to having a mock trial, for example. It's a good alternative to mediation if you want a little bit more of a concrete resolution in this case. But you do just have to be aware of the potential repercussions if you are the party that might reject the arbitrator's decision. Thank you.